there's a company that has a rooftop area that overlooks Wrigley Field, and this company and the Cubs are in a pretty massive legal battle.
Right, and so there actually was some litigation that happened about 20 years ago, and all the parties settled out, and then that agreement sort of went away. And the Cubs were super aggressive, and they went and sued the defendant in this case. It's called Wrigley View Rooftop. And I went and checked out their website. All the listeners should see it. It's really cool. It's like a really nice rooftop bar restaurant that looks right down into Wrigley. And so they sued them for misappropriation, false advertising, unjust enrichment, unfair competition, and unauthorized use of the Cubs trademarks, okay? And then the Wrigley Rooftop, they sued them back for what's called private nuisance, okay? And they said, look, we've got all these drunks and people messing with our property and doing other stuff that you guys cause for us. But at the core of it is kind of what you hinted on. You know, really the key theme is Wrigley Rooftop says, hey, the Cubs have no right to control the enjoyment of our private property, right? You can't tell us what to do within the property. Now, it's clear if their website, which it doesn't have it, has the Cubs trademarks, the Cubs logos, that type of stuff, that'd be clear misappropriation. It's not something you can do. But, you know, they have this nice property that looks over there. Now, they actually have old stands, you know, when they have, like, you know, redone seats from Wrigley, and they have them up on this rooftop. They serve, you know, hot dogs and everything else. So it's essentially a baseball experience that's there. But I think they have a really strong argument to say you can't dictate what we're going to do in our property absent. You can't say that you're affiliated with the Cubs. You can't use any type of Cubs logos or anything else like that.
Sports and Courts with Brett Hastings here on the Frangie Show, 1010XL and 92.5 FM. You know, Brett, when Hayes told me about this topic, it was interesting because I've been to a couple of major league ballparks in some big cities, and you always see the big, you know, skyscrapers, particularly if they're in the downtown area of said city. And I've always wondered, well, what's to stop, you know, whoever from just going into that building, go to the 30th floor or whatever, and peering out the window and watching the baseball game free of charge? What are the rules that'll apply to that? Because we're kind of talking about something similar here in Chicago with the Cubs, right?
Right. Yeah, I mean, you could always do that. I think where you're going to start to have a, quote, legal battle is when you start charging others for, you know, arguably the right to watch the Cubs game. Right? Mm-hmm. And so, or whatever game, if you're in Pittsburgh or in any of these other metro scenarios and you're talking about high rises like that, you know, so you could go and watch it and just do it yourself. And if you're not trying to profit off the event, then there's really nothing that they could do about it legally. Here, are they profiting off of the Cubs game? They are. But one of the things that's really strong in the law is that others, okay, are not really allowed to dictate your peaceful enjoyment of your own property, right? And so somebody can't tell you necessarily what to do in your property, and to that extent, you should be able to, you know, profit or do what you want in regards to enjoying your property and not having others dictate to it. You know, the line here, I think, is if people think somehow it's a Cubs-affiliated experience, you know, what have you. But, you know, the Cubs' strongest argument, and you know, potentially it could win on this, is to say, hey, look, they're essentially, you know, offering this ticketed or another corporate type of baseball experience, and that's impacting us, and, you know, we own the team, and they shouldn't be able to do that or to profit off of that without paying us.
If the Cubs could do it, obviously these are older structures and there's a finite amount of space. But if the Cubs could build something to obstruct the view of this company, could they be legally entitled to do that on their property, Wrigley Field?
100%, yes, they would be.
And do you think, is that something that, obviously they must just not have that option, would be your guess?
What I think this is about, I don't think the Cubs care whether or not they win it or lose it. You got to understand that there are several other properties, maybe not as prominent as this one, that have reached settlements and share revenue with the Cubs. for fear of being dragged into this litigation. Wrigley Rooftop has sort of said, you know what, we're not going to do it. They then didn't do anything, and then the Cubs came and sued them. So they said, you know what, we're going to sue you back, and now let's see. And so, I think these other places are, all out there rooting. They're kind of like North Carolina and North Carolina State rooting on FSU and Clemson when they were taking on ACC, right? They love to have legal precedent that says you can do whatever you want to profit in your property because of its proximity to this historic park.
This might be an impossible question for you to answer, Brett, but I'm just curious. All these new stadiums that are going up around the National Football League in particular, obviously we're going to have one right here in Jacksonville in a couple of years. When they're building these new stadiums, are they putting in, is there an acreage where the team owns it, where no one else can build in a certain, distance to the stadium to prevent things like this from happening in other sports?
I'm sure they contemplate it. I mean, one of the things you look at our new stadium. It is going to be covered, right? I don't think there's any way anybody could go and just watch the Jaguar game the way this stadium's going to be built. If you look down what the Dolphins play in, any of that stuff, sort of the, quote, modern type of building sort of goes and eliminates it. At the end of the day, I don't think it's that big of an issue for them. It's not that much in revenue. We still want to have the fan experience, for TV, but at the end of the day, it's all about, it used to be broadcasting them, but now it's all about streaming these games because that's where all of the revenue comes from. So even Wrigley Rooftop, the amount of, quote, money that the Cubs may say they go and lost is probably less than 1% of 1%. So I don't know that it's ultimately a driving factor. I think this is just something that, quite frankly, they're going out and litigating over the always scary P word, which is just principle, And so somebody's going to probably end up with a large legal bill and not like it in this case.
I remember something that was absolutely hilarious was back before the stadium got renovated here, I was sitting up in section 432, and companies would drive as slow as they possibly could over the Hart Bridge during games to promote their business. Because if we could see the Hart Bridge, obviously they knew they could see us. And so you would have situations like that because the stadium wasn't as enclosed then as it is now, which now obviously you can't do that. You won't be able to do that with the stadium of the future. But that kind of goes into it. People weren't watching games, but they were promoting their business by having a bunch of their company trucks drive as slow as they could over the Hart during Jaguar games.
That's right. So as long as you didn't get in trouble with the police, that'd be legal,
So how do you think this wraps up? Do you think you seem like you feel like Wrigley View Rooftop has the strongest legal argument in this case?
I think they've got a strong argument. They could end up having to pay some measure of damages if there's any misappropriation of the logos. Right? So I think you could win on the property issue, but they've really got to be clear and tight on that, right? Like they can't be doing anything to reference it. I won't say who, but a good friend of mine is really high up in one of the biggest ad agencies here in Jacksonville. And one time they did an aerial photo for a client in Tampa, but you could see the Tampa Bay Bucks logo, right? From this high up thing. They weren't trying to do anything, they thought, to misappropriate the Bucks logo. They got a letter from the Bucks, and the ad agency had to take care of their client and pay money to the Bucks because they believed that was misappropriation. And, Major League Baseball's right there, but the NFL and the NFL's teams, nobody's more aggressive in going out and enforcing and protecting, their logos and their rights and that type of stuff. So if there's a risk of exposure, it's for that. And I can see maybe Wrigley has to pay some money for misappropriation of the logo or putting it out. But from a property rights sense, I think they have a great argument.
I wanted to ask you while we have you, the college football landscape. We've talked in great deal about it, but they're still waiting on this settlement that's supposed to go into effect, I think, in the first week of July. What's your thoughts on the judge having not given her opinion on whether she is going to allow it? She's already pushed it back once, and I guess they fixed whatever the main objection that she had to that was, but she still hasn't ruled one way or another if she's going to accept it. and these schools are, basically 5 weeks away from having to shell out $20 million to athletes.
Right. There's still, like we've always talked about this. To me, it's still a load of BS because it's not really all about name, image, and likeness. It's ultimately about pay for play. And until we address whether college athletes are employees, there's still going to be a fair amount of chaos. But specifically to answer your question and the settlement, I think this is going to get worked out. They know that timeline is out there. The really minuscule issues that they're trying to, the roster limits that we talked about 2 weeks ago, that type of stuff, but as far as the amount of money that's going to be paid in the past, the amount of money that would be available going forward, that stuff's set into place. Now, a governing body and the commission of that and how that's going to go, I think they're kind of crazy. It's going to happen, and we're going to need that to happen, but that's something that's going to take longer to do, right? I think the payments will go forward. I think people can start operating and rely on house, but everybody coming to be able to agree to essentially have a ruling body and an NIL clearinghouse and those things, I think that's still going to take a while. So, it's going to be, not exactly completely ironed out anytime soon.
Brett, we'll get you out of this. Get you out on this final question. Greg Sankey, the SEC commissioner, talked to reporters yesterday and was pretty poignant in his comments, pretty directed towards the ACC and Big 12 that he's not overly happy with, kind of what their public discourse. If the SEC and Big 10 did decide to break away from the NCAA and obviously the other conferences, what kind of a legal battle do you think they would be undertaking to try to incorporate that enterprise?
Well, they could go and do it. I think the issue would be, do you leave, is Florida not going to be able to play in the NCAA basketball tournament, right? I could see them pulling out for football, but it would really be draconian. It would be wild, if they pulled out of all of sports. But the NCAA could still go forward. You would just have, Big Ten, SEC matchups. So they could go and do it. I think the issue would be, similar to what we've seen in golf, right, with the Live Tour or what have you. If the NCAA, the NCAA is the worst officiating body in all of sports, and we know that. But all of these schools and all of these things that go on this fantastic track, meet that you guys are talking about for people to get to Oregon, those go from coast to coast, and there are a lot of reasons that we would want to keep that together. The NCAA basketball tournament, those types of things. I've said for a long time, I didn't think that college football would remain in the NCAA for long. I still think we're going to have 4 mega conferences. Those will be 16 teams apiece, and there'll be 64 programs that compete for the national title in football. I still think we're a little ways away before they all pull out of it with the NCAA. But, based on the sort of just the demeanor of Sankey the other day, it does seem like the SEC and the Big Ten may do something like that, coming up. But I also think that there's a lot of frustration with Greg Sankey and the SEC because they're realizing right now, after the House settlement, there are a lot more questions than anybody would want to see in collegiate athletics and not as many answers as people would want right now.
Yeah, and it just doesn't seem like that House settlement, even if it gets approved, it just doesn't feel like that's going to be the final thing here. It almost feels like people are can't wait to then sue off of the settlement. So, unfortunately, it looks like the landscape is going to remain pretty murky, even with the House settlement, correct?
Yeah, absolutely. Yeah. Totally agree.
Yeah. All right, Brett Hastings, we certainly appreciate it. We will look forward to talking with you next week when we come back on the Frangie Show. Hacker had a chance to catch up with Jaguars linebacker Devin Lloyd. You will hear that coming up next. You're listening to the Frangie Show on 1010XL 92.5 FM.